Hello, my name is Robert Cost, and I'm the principal attorney with General Counsel Online, an online, on-demand legal service offering subscription-based, fixed-price affordability. General Counsel Online produces LAWGORITHMs, which simplify business decision-making about legal matters. LAWGORITHMs are designed to help the business person think clearly and logically about everyday legal issues, and by so doing, make better business decisions. This LAWGORITHM is designed to help you decide whether to register your company's creative work or information product with the United States Copyright Office. I'll give you the short version in this video, but if you'd like a more detailed white paper or presentation version, I'll show you how to get it at the end of this video. We have a lot to get through quickly, so let's go. Registering a copyright is a simple and inexpensive process that creates a record of copyright ownership with the Copyright Office, a part of the Federal Library of Congress. To be clear, you do not need to register a copyright in order to own it. You own a copyright in a work of authorship the moment you create it and record it in a, quote, tangible medium of expression. That is, the moment you write it on paper or on a computer, the moment you photograph it, audio or video record it, etc. And with this claim to ownership, you can bring a lawsuit in federal court to enforce your copyright. So why register? The answer is that registration has some very distinct advantages which will be very important to certain kinds of copyright owners. But first, you need to be sure that what you are registering is copyrightable in the first place. If an item is not copyrightable, you cannot register it. Most original works by an author, composer, or programmer are copyrightable, but there are certain types of works that are not. First, ideas or abstract concepts. Things that have not been reduced to a particular concrete expression, these are not copyrightable. A general rags to riches storyline is not protectable, but a biography of Andrew Carnegie is. Next, methods, algorithms, processes, procedures, and systems are not copyrightable. Of particular note for software authors, copyright does not protect the algorithm your software implements. And similarly, cooks may be disappointed to learn that their recipe is not copyrightable. Next, works that lack a, quote, modicum of creativity are not copyrightable. This includes customer lists, member lists, white pages, telephone listings, log files, and other similar kinds of works. Compilations like this may be copyrightable if they introduce an original sequence, structure, or organization, but the underlying facts are simply not copyrightable. Finally, business and personal names, book titles, song titles, fonts, fashion designs, blank forms, short phrases or slogans, none of these are copyrightable. If a work's not copyrightable, it may nevertheless be extremely valuable to the business. If so, one should investigate whether it's protectable by trade secret law or by patent law. These are topics we'll address in future LAWGORITHMs and won't go into right now. But let's assume that your work of authorship is copyrightable. Your first task is to determine its value to the business. The value of a work is a function of its role in the business model. In general, an information product can perform 4 different kinds of roles. It can be a secret, a product, an asset, or it can act in an ancillary role. The business importance of a work and the benefit of registering a copyright is in general greatest with products, followed by assets, and then by ancillary works. We will return to secret information in a moment, but let's begin with the work's role as a product. This is the case where the work itself is the item for sale. It alone, or in combination with other resources like labor, is what the business has to sell. The business is typically an author, publisher, distributor, or packager of a work. It is selling a book, a movie, a computer program, a newspaper, a game, a song, a blog, a video, a report, etc. These kinds of businesses comprise the, quote, intellectual property industry, and they generate over $6 trillion in gross sales and make up over 38% of the U.S. gross domestic product. Next, a work may be an asset. That is, it may provide the business with a competitive advantage of some sort. It may even be counted, quote, on the books as an intangible financial asset of the business, having a market or intrinsic value. Advertising is perhaps the preeminent example here, but other copyright assets might include studies, reports, surveys, software tools and infrastructure, and knowledge in the form of employee presentations and publications. Finally, the work may be an ancillary or supporting work, whose role is internal to the operation of the business. Employee manuals, procedures manuals, memoranda, company signage, and internal publications are examples of these kinds of works. If the work is none of these things to the business, it's likely that it's not worth registering the copyright in. Examples of these kinds of information products that are not worth registering include typical emails, voicemails, and other inter-office or internal communications, as well as data about the operation of the business itself, such as its financial plans, payroll data, building data, facilities, employee information, and so on. Let's return to the case where the work's value comes from its being a secret. Things like market data, customer databases, chemical formulae, software methods and techniques, engineering plans, planning documents, these may be copyrightable, but often derive their value from the fact that competitors don't have them and cannot easily make them. If this is the case, and the business has been or will be diligent about keeping the information secret, copyright registration should probably not be pursued. This is because registering a copyright requires that you deposit copies of the work with the Copyright Office, and this deposit is publicly available. This destroys any claim you might have to a trade secret. So if the item's value is in its secrecy, you should not register it. But assuming that the work is copyrightable and valuable to the business and is not a secret, the next step is to consider the benefits of copyright registration in relation to this value. In a nutshell, the benefits of registration are as follows. First, there are so-called statutory damages. Ordinarily, if your work is infringed, you'll have to prove actual damages, and these are most often measured in terms of lost profits, and they can be very speculative and difficult to prove. Registering your copyright means that you can instead seek statutory damages. These are fixed by statute and range from $750 to $30,000 per infringement. In the case of willful infringement, statutory damages may be as much as $150,000. Next, registration provides a presumption of valid ownership. Ordinarily, this burden of proving valid ownership would be on you as the copyright owner. But registration switches the burden to the defendant to prove that the works do not belong to you. This is important because you may not have time for legal motions and arguments if you're seeking an injunction to stop harm that's occurring right now. Registration also provides import protection. The U.S. Customs and Border Protection can seize and detain infringing copies of a registered work being imported into the United States. The copyright owner can also petition the International Trade Commission to exclude infringing work from import in the first place. Next, registration creates a searchable public record. Not only are potential infringers on notice and therefore potentially liable for willful infringement, but parties seeking to contact you for licensing reasons are able to find you through your entry in the Copyright Office database. Finally, a work must be registered with the Copyright Office before any lawsuit can be brought. Because registration may take anywhere between, say, 2 and 12 months, this delay could be decisive if you're seeking to address an imminent harm to your business. Certain works may have utilitarian value. That is, they may perform a useful function. If the work's value is utilitarian, you may want to both register its copyright and seek patent protection for it. This is particularly true in the case of computer software, where the written code is not merely an original, quote, literary work, as the Copyright Office calls it, but may embody a new process, machine, manufacture, or composition of matter. In this case, you should consider filing a patent on the work in addition to registering it with the Copyright Office. Bear in mind that an inventor has 1 year from the date an invention is publicly disclosed, used, sold, or described to patent it, and that registering a work with the Copyright Office will set this patent clock ticking. In most cases, copyrightable works are not utilitarian and not patentable. But if you've made it this far through the analysis, we've already concluded that you should register it with the Copyright Office. Registering a copyright is not difficult or expensive, and it can be done online or through the mail. Registration requires that you complete an application, pay a fee, and deposit 2 copies of the, quote, best edition of the work with the Copyright Office. Now, best edition refers to the criteria that the Library of Congress determines for the deposit to be suitable for its purposes. Well, once you've registered the work, no further action is necessary. Unless there's a problem with your registration, you should receive a certificate from the Copyright Office in, like I said, between 2 and 12 months. Congratulations! Your work is now part of an ever-growing body of art, literature, and software in the nation's historical memory. It will be protected by federal law in federal courts for the life of the author plus an additional 70 years. For an anonymous work, a pseudonymous work, or a work made for hire, the copyright endures for a term of 95 years from the date of its first publication, or for 120 years from the date of its first creation, whichever expires first. Not bad for a $65 filing fee. I hope this logarithm is useful to you in thinking about your own works of authorship. Please feel free to download a copy at the web address above or in the copy below. As always, this logarithm should not be construed as legal advice. Consult with your own attorney before seeking a copyright registration. Everything turns on the specifics of your business, on your work of authorship, and on your situation. If you're a Pennsylvania company, we welcome your inquiries at generalcounsel.online. Thank you for your time and attention, and best of luck to you.